our initiative of Brown Bag Lunch Series. This is our second Brown Bag Lunch. So today we have the pleasure to have Brennan Platt with us. He's an Australian lawyer and he's currently lecturer of international law at the University of Cambridge. And we will discuss a very interesting topic on the, we call it, science and sovereignty. So the use of scientific evidence in international disputes. So this is a very informal meeting with friends and fans of international law and of you. So welcome again, and thanks to everybody. Then we will have a conversation.
Thank you. Well, the first thing I must say is thank you very much to Maria Carmelina and everyone here at La Sabana. I am delighted to be here again. If I struggle to show my enthusiasm for being with you, it's only because of jet lag. I've been in your beautiful country now 7 hours, and I have taught for 4.5 of those hours. So it's been a quite difficult entree into life in Colombia. But nevertheless, it is a great thrill to be back here, as ever. I'm also very glad to participate in this initiative. I think it's a really excellent thing to be able to gather for these more informal types of conversations. And I'm going to emphasize the informality, not only because it is a national stereotype of being Australian that one is traditionally informal, but also because I hope that will prompt you to interrupt me at any moment with questions or queries or issues that you'd like me to discuss. I think there's the opportunity for you to get more out of it if there are things that I can comment on that more directly relate to your interests. That's certainly something that I would aspire towards. So I'm going to aim to introduce you to some ideas about the important issue of the treatment of scientific evidence in international dispute settlement for about half an hour or so. I do tend to speak too much, so I'll probably go longer than that. But then to open the floor and take questions that some of you might have. And again, that shouldn't discourage you from interrupting me during the discussion because, as I say, that's going to help you get more out of it, and it will certainly help me get more out of this experience as well. So, what is the significance of the topic that I'm going to discuss this afternoon? Scientific evidence and its particular treatment in an international context. Scientific evidence is something that anyone who has been involved in litigation before domestic courts will doubtless have had some experience and will be familiar with commissioning and questioning expert evidences, cross-examining the expert evidence of opponents, and trying to manage the interaction between some really very different types of understanding the world and different types of decision making, because science and law fundamentally boil down today to different ways of approaching decisions about how we should regulate and manage our affairs. And it is becoming increasingly significant at the international level that states are agreeing to delegate, in a sense, the decision-making over important regulatory matters to scientific experts. This is especially pronounced, of course, in the field of international environmental law, but it's something that we see also in respect of economics, in territorial disputes, in maritime affairs. It's become a very significant thing. But both of the disputes that I want to discuss today, the case studies, come from the ICJ and relate to environmental matters. but it's something that I need to emphasize right from the very beginning. These two case studies really represent, from my perspective, the start, thank you very, very much, the start of a story that looks to continue. As states are increasingly willing to commit themselves to global or at least regional frameworks for managing shared environmental resources. And in fact, this is an area where international law has singular significance in the world, because without international frameworks for coordination, the shared and finite resources of the environment that we all require will unfortunately be held hostage by free riders, by the lowest common denominators, by those who are least respectful of that shared resource. So the significance of this matter is, I think, pretty obvious when you think about it in terms of global governance and of course, the environmental pressures affecting us all today. But it's also significant then from a legal perspective, because it's prompting new questions about not only the character of international legal rules as international law thickens, if I can use that term if you've come across it before, as the rules become more detailed, as the regulation is more dense. We're not simply relying on general statements of principle or general articulations of norms, but committing to much more detailed frameworks based in scientific understanding, based in trade flows, based in our understanding of migration patterns or whatever it might be. As international legal rules become more detailed, then we can anticipate that these types of detailed disputes will become more commonplace. And understanding how we deal with expert bodies of knowledge and give them a meaning within the law, dealing with expert forms of evidence and give them effect within dispute settlement is, I think, of the utmost importance. I'm going to focus today, as I said, on the International Court of Justice for two reasons. The one is selfish. I know the most about it. I've spent a lot of time at and studying the ICJ. My first book is on evidence before the ICJ. And so it's something that I can share among friends informally, some of the insights that I've been able to gain from that experience. The second reason is that these two recent cases are both ICJ cases. So we can set the parameters with a little bit more solidity if we focus just on one particular body. Because one of the things that is very important at the international level is the implications for court practice of the constitution of those bodies. Now, that seems like a pretty trite statement. Of course, every court is confined by its process. Of course, every court is structured by the rules according to which it was set up. But it's a little less straightforward in the ICJ because of the reliance, the contingency of the ICJ's procedure and decision-making authority on the consent of the states appearing before it. I'm probably boring students who've heard this last year, and I'm spoiling the lecture that I'll be giving to my students tomorrow, but it's inescapable that consent has an extremely extensive structuring influence on the ICJ. So much so that every dispute really needs to be treated as separate. The states who participate, who give their consent to engage in litigation before the ICJ, have a much more extensive freedom than any domestic court to tailor the process, to tailor the evidentiary practices according to their own preferences. It is the parties who lead the process rather than the court. And that represents a really subtle but significant difference when evaluating the ICJ's practices as opposed to a domestic court. What that means is also that the ICJ has to be viewed in its own terms. It is a very strange beast. It is unique among judicial decision-making bodies in the world because of its heritage, because it represents a necessary amalgam of common law and civil law approaches to dispute settlement. The reason being, of course, is that this body needs to be equally amenable to common law and civil law litigants. It needs to avoid the appearance of any bias or preference for states coming from either of those traditions. So the ICJ has been created as a bit of a car crash, if you ask me, a Frankenstein, I often say, of civil lawyers and common lawyers' expectations for litigation. So, from a common lawyer's perspective, there are a lot of familiar aspects. The oral procedure is required, despite the fact that most civil law states at the time of the formation of the court suggested it was redundant. Get away! We don't need to talk to each other in a courtroom. We can use documentation as the basis for our dispute settlement. The common lawyers wouldn't have it. So oral proceedings are a compulsory component of ICJ proceedings. That means that there is the possibility for questioning and cross-examination. That very, very rarely has happened historically, but the cases that I'm talking about today show a bit of a change in that respect. The other thing that is very familiar from a common law perspective is the fact that the responsibility for the presentation of the case and for the identification of relevant materials falls upon the adversarial parties themselves. They bear the burden of bringing before the court any information that they deem relevant. That's a really important point when we think about the limitations of the court later on. What's particularly strange from my perspective, coming from a common law litigation background, is the fact that alongside this common law structure is built a civil law facility, in the sense that the ICJ has powers of investigation that, from my perspective, are really, really weird. No court from a common law jurisdiction is able to call its own witnesses, to request production of evidence, to initiate its own investigations, to nominate particular experts, or indeed to require a visit to the site. That none of these things happen in a common law court. The court is confined to its premises and it makes its decision wholly on the basis of the portfolio of material that the two sides have brought before it. The ICJ has both of these faces. It can call its own witnesses, request its own evidence, appoint its own experts, as we'll see, as well as giving the primary responsibility to the parties before it. And we see in that a body which has almost unequalled power to control its own proceedings. Almost unequalled power to conduct proceedings as it sees fit. So the strange thing is that it almost never does so. Very, very seldom has the ICJ exercised any of the powers that I've just described to you, particularly any of the powers of initiative that it enjoys. It doesn't request site visits. It doesn't request the attendance of witnesses. It doesn't undertake its own investigations. It doesn't call its own witnesses. Why? Sovereignty, consent. Because the court will not want to dissuade its potential customers, frankly, clients, other states with disputes, from coming before it by being too interventionist, by being too demanding, by being too controlling. It prefers instead to put itself at the service of those states rather than demanding that those states do what it prefers. So you can see this reality in another situation. I told you we're going to focus on environmental disputes today. And you'd think, okay, environmental disputes have for a very long time. There's nothing new about environmental disputes. In fact, some of the old disputes in modern international law's history involve the environment. Things like the Khotsov factory cases about transboundary pollution. We've known about environmental disputes for a long time. We've known that they involve difficult questions of fact. Why don't we create a system that is appropriate for it? Well, we did. It was such a good idea that we gave the ICJ the power to set up a special chamber for environmental disputes. I don't know if any of you know how many times that chamber has been used, but I don't think any of you will be surprised to learn that the answer is 0. Pulp mills is not an environmental chamber. So the chamber was, and pulp mills is one of the 2 cases I'm going to be talking about. The idea was that there would be certain judges who would develop over time expertise in dealing with factual and data matters relating to environmental issues, and that they could deal with them more expeditiously. So they would sit in a smaller number, 5, 7 or 9, and at no time has that chamber being actually ever convened. There is also the possibility for ad hoc general chambers to be used. They are used sometimes, it must be said, but the specific chamber for environmental disputes has remained neglected. Why? States apparently don't want it. Or so it has seemed. We see in these 2 cases, as I've said already, a hint of a change. I want to note a few other things, though, that sovereignty impels, which is a limitation in an evidentiary sense. The court really struggles if it feels that there is information that falls within the control of one of the litigants that state has not produced. And on a few occasions, the court has been convinced to request production of that evidence, and if the other state refuses to do so, or claims that it doesn't have the evidence, then the court really doesn't have much power, frankly, to penalise that state or to draw inferences. There is the prospect for drawing an adverse inference from the non-production of a requested document, but never has the ICJ actually done that. It has used a few strange, circuitous expressions to say that it's not very happy that its request for the production of information was not met, but it doesn't go so far as to say that it has penalised that party by drawing an adverse inference against them. Another point that I want to make then is that some unusual practices have emerged then within the ICJ because of this particular framework. And in particular, what we've seen in recent 15 years really is states appointing experts, what you would think would be appointed as an expert witness in a domestic litigation, making them counsel instead. So what happens, there's no limitation on who can appear before the ICJ, there's no license requirements, there's no expectation of rights of audience, requirement of rights of audience, and there's no size limits. So what states realised they could do was appoint as one of their lawyers, we call them agents in ICJ proceedings, appoint a geographer or a hydrographer or an anthropologist or an ice flow specialist or an atmospheric engineer or whatever it might be, and make them legal counsel, make them an agent for the case. The reason states would do that is that when those people stand before the court and introduce all of this evidence that is drawn from their own expert knowledge, it remains free of the possibility of cross-examination. It cannot be subjected to direct interrogation by the opposing side because it forms part of the basic pleadings of that state. It was a shifty practice that the ICJ has now become aware of and indicated its opposition to. But it's just another indication, I think, of the specificity of this dispute settlement forum. So, perhaps for some or all of these reasons, the court has famously tried to avoid confronting factual questions head-on. And there are a couple of cases in particular where the court has expressed its frustration and the difficulty it has experienced when dealing with factual questions. The other point I should state about this is, of course, states, because of the significance of their consent to the conduct of proceedings, have been free to submit whatever evidence they have considered even vaguely relevant for disputes. They literally throw the kitchen sink at the court, and the court has been overwhelmed in a lot of cases by this barrage of data that the states are able to find. They throw it at the court and leave it to the court to sift through it all and work out what's relevant from what's not. And that's a pretty standard litigation strategy, of course, if you come from the better resourced side of a private law dispute. You'll try and smoke out your opponent by overwhelming them with information, knowing that you are more likely, by virtue of superior finances, to deal with any question they throw at you, whilst all the time raising the costs that are incumbent upon them. And the same seems to apply here. The court has a few times tried to convince the states to put a limit on the material that they present before the court, but again, if the states decide, for whatever reasons, and it's usually a reason of domestic politics actually, that they would rather throw everything at the court, then the court is powerless to stop it. And we've seen a few examples where states are really litigating in two respects when they appear before the ICJ. One is, of course, before the bench in the eyes of the international community. The other is before their own domestic political constituencies. They want to be seen by their own citizenry as doing everything they possibly can to win the battle. And if that means bombarding the court with 400 witnesses, then so be it. And in fact, there's a notorious example in the Bosnian genocide case. Serbia tried to overwhelm little Bosnia-Herzegovina by seeking to introduce the witness, something like 150 witnesses into testimony, knowing that that would make the dispute last about a year or two. And the one time the court has been really strong and pushed back to the parties, it insisted that they only introduce a limited number of witnesses and only give them, I think it was 12 minutes of examination. And when that decision was reached, all of a sudden 130 of Serbia's witnesses miraculously became less important. And in fact, Serbia never brought them to The Hague. So that's just a bit of backstory about the particular evidentiary difficulties that the ICJ encounters. There are many more relating to things like non-appearance and non-disclosure that again stem from this basic requirement of the consent of sovereign litigants that I don't have time for now. Instead, what I want to do is go through the two important recent cases where scientific evidence has been confronted directly by the court. And the first is pulp mills, which Julian has mentioned, and the second is the recent whaling in the Antarctic case. Now, I'll be brief in my rundown of these two cases because I really want to focus on the matters relating to science and evidence. But in the pulp mills cases, I'm sure people in this part of the world are aware, Argentina sued Uruguay for alleged violation of both procedural and substantive obligations that bound the two parties following Uruguay's commencement of construction of a paper pulp mill on the River Plate. It was the River Uruguay, wasn't it? Excuse me. Now, the case was interesting for a range of reasons. One particularly interesting thing was the approach taken to interpretation of the treaties. The ICJ identified in the thicket of treaty obligations that Argentina and Uruguay owed to each other as neighbours, and indeed the thicket of obligations that Argentina and Uruguay, as part of broader regional and international communities, have come to owe each other, that there is now, as a matter of customary international law, a binding obligation upon states to engage in environmental impact assessment before undertaking any works that may have some type of detriment for the shared environmental resources that may run the risk of creating transboundary harms. That was a very novel, innovative element of the court's decision that has been received warmly by environmental activists especially. But more controversial was the court's commentary about this important aspect of scientific evidence. Because among the various obligations that were alleged to have been violated by Uruguay when it commenced construction of the paper pulp mill were commitments to protect the well-being and the integrity of the river ecosystem. So protecting the flora and fauna of the region, protecting the quality of the watercourse, ensuring that the water remained good, I suppose you could say, so as to allow a fair and equitable use by all of the littoral states or the river bounding states upstream. In order to show and to argue against these alleged violations of the obligation to ensure the continuing health of this river ecosystem, both Argentina and Uruguay admitted a very large amount of technical scientific evidence before the court. Some of it, but not much, was brought in the form of an expert witness, but perhaps the bulk of it was led into proceedings by these expert advocates that I've mentioned before. Individuals who were appointed as agents, who were brought before the court to present the parties' pleadings, but who happened not to be lawyers, but instead ecologists, hydrologists, hydrographers, and so on. And the court was given cause to reflect upon its engagement with scientific evidence because of the volume of material and its complexity and significance for the outcome. It was, of course, crucial for the court to arrive at a view of the weight of this very technical evidence in order to determine whether or not Uruguay had violated these substantive obligations to protect the river's ecosystem. And the court asked itself, are we capable of doing this? Perhaps surprisingly, it answered in the affirmative. It thought it was capable of deciding on points that required a lot of contextual understanding of data about water flows, silt patterns, impact on particulates in the air, flora and fauna, and so on. But a few of the courts questioned whether or not it would have been better in the circumstances for the court to have appointed experts of its own. And in particular, in the joint dissenting of opinion of Judges Alcosone and Simmer, they took a very critical view of the court's practices in this case and in recent years. And I hope you won't mind a little bit of gentle self-promotion if I draw your attention to that particular opinion, because it is a rare example of the court quoting work by academics. ICJ usually doesn't do that very often, but in this particular instance it did, and I'm happy to say it quoted me. So it's important that I draw that to your attention, I think, if only to make me feel better in my jet-lagged state. Judges Simmer and Alcosone exposed for the first time, or the second time, because the first time was in my book, the fact that in recent decades the ICJ has, when confronted with highly complex matters of technical evidence, in secret appointed expert assessors of its own to assist it in evaluating the technical data that was brought before the court. This is, frankly, quite outrageous, because the court never drew the attention of the parties to the fact that it had gone about appointing a secret expert, what has now become known as a phantom expert, of its own to assist the court in its deliberations, to assist it in evaluating the evidentiary materials. And Judges Simmer and Cosone were quite brave, I think, in drawing this practice out into the open for the express purpose of exterminating it. He said, these judges said, it is quite clear that the court has struggled to understand complex technical data. We are, after all, but judges. We're not trained in hydrology. We are not trained geographers. We are not trained in fluid dynamics. We don't understand silt patterns. We don't understand particulates in the atmosphere, and so on and such forth. So it is appropriate for us to acknowledge that and to seek assistance, and for us to query the credentials of experts, appoint someone who is in the service of the court, not in the service of either of the litigants, someone who doesn't have a vested interest in the outcome of the case, and someone who can help us understand what all of this means. We should have done this here, is what they suggested. The majority of the court actually felt it was a pretty straightforward matter, and they declined to appoint their own experts, felt that they were capable of understanding the data themselves, and arrived at a final conclusion that effectively supported Uruguay's arguments in the substantive matters. The decision of the case was that Uruguay was not in breach of its substantive obligations to ensure the health and well-being of the river ecosystem, but it had breached its procedural obligations by failing to consult fully with Argentina and by failing to complete an environmental impact assessment. So you see a real division on the bench in this case. Some judges thinking, we're perfectly capable of dealing with data coming from highly specialised physical disciplines that we have no experience in, and others realising this is well beyond our comfort zone, well beyond our competence, and in fact we should appoint somebody to assist the court. I will note that in that particular case, the court also expressed its disapproval of the practice of expert advocates or expert agents. The use of, I'm picking on hydrologists for some reason, I don't know, but appointing an hydrologist as legal counsel was something that the court indicated its displeasure with. What impact does that have? Arguably none. The court can't prevent, can't punish, can't enforce that statement, but by indicating what they consider to be best practice in the future, the hope would be that states would adjust. And remember, states want to appear to be doing the right thing. If you end up before the ICJ, you are before the eyes of the international community, and you want to be seen to be doing the right thing. But nevertheless, there isn't much by way of firm enforcement that the court can use to insist upon those practices. The final point that I'll note actually about pulp mills is again the fact that the court was merely able to say that other states should be encouraged to produce information before the court if it was in their control and it seemed relevant to their opponent's case. But again, that is a fairly hollow threat, if we're honest. There is no reason why another state should be required to do so other than for reasons of good faith.
Uruguay and Paraguay is quite even. I mean, both the states are South American states. They have resources in a similar way. Probably Argentina could be down there more than Uruguay. But what happens if it's a very uneven confrontation? Wouldn't that measure, that practice by the court, will be something that can be used to level? If you have something like, I don't know, UK, Iceland, or if you have USA, Nicaragua case, wouldn't you like the court to have an expert to analyze with them together, neutrally, the evidence that has been presented unevenly by both the states?
We don't need a hypothetical here because there is just such a case that is happening now. I've just been telling the first years about it. The Marshall Islands, global behemoth that we know it to be. I mean, I don't think many of us even knew it really existed much before this recent incident. But the Marshall Islands, a small collection of islands in Micronesia, I think Micronesia, the Pacific, population of 25,000 people, has sued before the ICJ 9 states. The USA, China, Russia, France, the UK, Israel, North Korea, India and Pakistan. 3 of those cases are happening. UK, India, Pakistan. The others, there's no chance. But those 3 cases are going on. And there will be a very significant disparity of arms in those particular cases. Now, part of what we were talking about before is the fact that sovereignty entails the recognition of the absolute formal equality of the parties appearing before it. And in a sense, it doesn't really matter to the court if one state has greater arms or greater access to resources than the other. But anyone who's been involved in any litigation anywhere knows that, of course, it has a very big impact and can distort the conduct of proceedings if one party is well-resourced and well-advised and the other is not. What is likely to happen in the Marshall Islands case, by the way, is most of the most familiar and best experienced international advocates will appear for them for free. That doesn't mean they can get the evidence that they need, though. So what the Marshall Islands is claiming, it's quite an unusual claim. They are bringing 2 different types of claim. One is against the UK and the other states who are members to the Nuclear Non-Proliferation Treaty. And they are suggesting that the obligations set out in that treaty to take good faith steps towards dismantling a nuclear arsenal, so it's not just to not proliferate, not just to expand, avoid expansion of a nuclear arsenal, but to take actual steps towards decommissioning the nuclear weapons that exist already, that the UK has not been fulfilling that good faith positive obligation. It's very, very difficult, as you would know, to enforce violation of a positive obligation. And we'll be very interested to see how that case plays out. Marshall Islands is then making a similar claim on the basis of customary international law, which is even weaker still. But how the Marshall Islands will have access to evidence about the steps taken by the UK is hard to know. We'd have to rely upon the UK to want to show its own conduct in the best light by producing the most information it possibly can. But we can't deny that the UK has form in this regard. The very first case before the ICJ, the Corfu Channel case, was a case where Albania sued the UK. Actually, it's a transboundary harm case, some people say. It's about an obligation to not allow your territory to be used so as to affect harm upon neighbouring sovereigns. And we now know for a fact, well, the allegation was that the UK was aware of the placement of landmines in the Corfu Channel. And Albania was being assisted by Yugoslavia, actually, which I think was mindful 2 things. One, some sort of kinship, solidarity, and the other was the inequality of arms. And arms, I mean, in terms of litigation preparation sense, not a military sense. And Albania requested a particular log that would have shown the knowledge of a British naval officer in the relevant place at the relevant time. And the court listened to Albania's request and made that request of Great Britain, which did not did not meet the request. I'll put it as neutrally as I can. They did not produce the document. And if I recall, they didn't make much of an explanation as to why that was, whether they couldn't find it, whether it didn't exist, whether it was irrelevant. I genuinely can't remember that part, I'm sorry to say. But we now know from recent archival research in the National Archives in Kew in London that that document did exist, and had it been produced, there is no question in my mind that that decision would have been different. Absolutely no question whatsoever that that would have been a different outcome. But what can you do?
What about the power of shifting the burden of proof? I mean, isn't that something that because I completely understand what you're saying about the ICJ having this double being an adversarial court, but at the same time being a civil law kind.
Yep.
Being a civil law court, isn't the court able to shift the power of
So
the group and saying, look, you are in a better position, and
Yep.
in that sense, it will be against your claims, the fact that you don't.
That's exactly what Argentina argued in the pulp mills, that they said that the way environmental law is going, the burden should be shifted upon the state against whom the allegation of wrongdoing has been made. And that Uruguay should prove that it hadn't created any particular harm, rather than Argentina being required to show that it had. But the court rejected that argument, actually. It was pretty clear. It said that it is always the case in ICJ practice that a matter falls to be proved by the side which is alleging it. Now, and it's not that you're the applicant so you've got to prove it, it's that you're alleging this point so you have to show it. And the Argentinians said, well, hang on a minute, there is a notion developing under international environmental law of the precautionary principle, which is basically saying in circumstances of scientific uncertainty, the risk flows one way or the other, and that principle should be applied here so as to shift the burden onto the state against whom the allegation is made, if at least the allegation can be established on a straightforward prima facie basis. And the court didn't buy it. It didn't accept it. And part of the reason, I think, is the fact that the precautionary principle is not as well established in positive law as Argentina might have liked.
And I will add something to that, and it's the fact that there is the obligation, and it is an obligation of customary international law. I promise that I don't intervene anymore.
No, please do.
But it's because of the environmental impact assessment, which is a clear obligation recognizing both mills as customary international law, but the content of the obligation, the requirements to fulfill an environmental impact assessment, they're not positive. It's a margin of appreciation.
Yeah.
Every state can develop. So in that sense, I think that's an example not very helpful for the purpose of shifting the burden of proof. But what about if
I would say
maritime delimitation or something that is far more...
Well, maritime delimitation got nothing to do with that at all. But in terms of your point about EIAs, the reason why the court is much more ready to go that route is that they're really only procedural obligations. So it doesn't fall upon a substantive assessment of whether one state has created a particular consequence or not. It's whether you did the right thing or not, or whether you did enough or not. Now, if you think that an obligation to carry out an EIA is tantamount to a reversal of the burden of proof, then that's getting you closer there. I wouldn't see it in quite the same terms. I think burden of proof is something that relies on a dispute settlement framework, whereas an EIA is something that has a much broader existence and a scope that goes far beyond litigation. It is clearly a significant, innovative step, but I think it's interesting that the court didn't accept the argument that you're making, which runs a much broader, it has scope for being a much broader impact, because then it invites questions as to when burdens of proof can be reversed. When does the onus shift? And we don't have any practice that really assists in that regard, unless there is a specific stipulation in positive law. But bear with me, because let's talk about the whaling case, because the judicial review aspect of the whaling case is extremely interesting from the perspective of the questioning that you've been given. The reason I say maritime delimitation is totally different is because... Of course you are, yep.
The problem with proof, with evidence, regarding the existence of an extended continental shelf.
Sure,
that's
and
a
that...
huge issue.
It's
proof. Is it Nicaragua saying I have it, supposedly it is, or is it Colombia saying no, you don't have it?
Well, in that particular instance, it shouldn't matter, because an extended continental shelf lies outside the sovereign space of either state at this particular moment. So finding the evidence one way or the other is entirely within the scope of either party's powers. So reversing a burden of proof wouldn't have any bearing there. But it is a technical matter, the outer continental shelf, that was also outside the scope of the court's decision. It was only asked to articulate a principle for that rather than making a decision on the facts. You wouldn't have abided by it anyway. So let's look at the whaling case, which is a much more recent case. And it might be interesting if, again, you think, what's going on here? Because there are two states who are relatively equal, Australia and Japan. And in fact, a really, really interesting thing that's coming out of the whaling case from the perspective of international environmental law is a question of standing. So in international law, along lines not dissimilar from that we've just been discussing in respect of burdens of proof. And let's not even start about standards of proof, because that's an even bigger mess in international practice. Because that has been shifted, and I think the court knows that has been problematic enough in itself to then allow flexibility of the onus of proof shifting would be a free-for-all. What's interesting in the whaling case from a procedural perspective is the fact that Australia was allowed to bring the claim. Australia brought suit, and again it's another interesting thing about the link between what happens internationally and what happens domestically. There was an Australian election, and the Australian Foreign Minister, well, at that stage he was only the Foreign Minister, well, he was only campaigning for that position, was a rock star. His name is Peter Garrett. I don't know if Shakira has any political ambitions here in Colombia, but imagine she ran for Foreign Minister on the basis of suing someone for an environmental cause. That's exactly what happened here. Peter Garrett was campaigning. He's a funny man, very tall, bald, and dances in a very funny way. A lead singer of a band called Midnight Oil, who, it must be said, produced good music. Anyway, as a vote-winning claim, he pledged that Australia would sue Japan before the ICJ for its continuing whaling activities. And of course, when the election was won, he had to follow through with that commitment. Again, everyone thought, why is Australia doing this? What has Australia got to gain? Why are they going to spend their money taking Japan to court? And everyone was very, very sure at the time that Australia had no chance of winning this case, actually. And in fact, the reason it was won was on the sophisticated way Australia pulled apart the scientific evidence that Japan led, actually, truth be told. But Australia claimed standing because of the fact that the International Convention for the Regulation of Whaling included various obligations which, according to Australia, were owed by all states parties to all other states parties. So Australia didn't lose anything by having whales killed, but the entire community of states who are party to the ICRW, the Whaling Convention, lost. So as a party to that convention, Australia claimed standing to bring the matter, and that succeeded. This is an example of litigation on the basis of a violation of an obligation erga omnes partes, if any of you can remember or know anything about that. Basically, it says that within treaty frameworks there are certain types of norms that are owed to everyone, which is quite different from the structure of most international norms, which are owed in a direct bilateral way. Yep. Now, one of the reasons why Australia decided to pick this fight with Japan was jurisdiction. Again, I'm spoiling my lecture tomorrow, but Australia and Japan are both signatories, both participants in the optional clause declaration system. They have both accepted as compulsory the court's jurisdiction of certain categories of cases, including this case. Japan argued otherwise, and we don't need to worry about that, but the court found that it did have jurisdiction. So what was the case about? Australia claimed that Japan was violating its obligations by conducting whaling under the auspices, or in Australia's view, under the camouflage of the so-called scientific whaling exception. And Australia said, since the Whaling Convention was ratified in 1952, I'm going to say, since then, times have changed. An argument not dissimilar from the argument that succeeded in pulp mills about EIAs, actually. They said, look, the thicket of rules in this area has changed so much. So we should take heed of that and interpret this treaty term, this scientific whaling exception, in the narrowest way possible. That you say, if you look at the Whaling Convention, it started out as an attempt to balance sustainability with exploitation. So there were environmental and commercial concerns all the way through. But since the creation of this framework, we've been able to agree on a moratorium on factory fishing, banning whaling in the Southern Ocean, for example, banning the hunting of certain types of whales like blue whales, sperm whales, humpback whales, not minke, for example, which are like the pigeons of the sea, apparently. But we've been able to agree on all of these other types of prohibitions, and they all point in one direction, which is shifting the balance in favour of ecological concerns, in favour of sustainability over commercial exploitation. That means that this scientific exception, a scientific exception to the ban on whaling, should be the narrowest possible exception. And Japan disagreed. It said, well, no, hang on a second. We are a party to this convention, and we only became a party to this convention on the basis that we had this entitlement. We have objected consistently to all of these other changes, to all of these erosions on the freedom of states to participate in whaling activity all the way along. And so long as we can take a good faith view that what we're doing is scientific, then it doesn't matter what you think. You might think that what we're doing is commercial. We think it's scientific, and that's the end of it. That is a good faith assessment of what is being done here. And the court pushed back on that. This is a really important aspect of this judgment because it accepted the possibility that a state's compliance with, again, a almost positive obligation in some sense, though in others not, was something that could be subjected to review independently. The basis for the review was still a very high threshold. I don't know what the basis in administrative law here is, but in Britain it's a very high threshold known as Wensbury unreasonableness. Unless something is absolutely, completely ridiculous, then it will be acceptable. The court tended more in that particular direction, but it said we can assess, based on the evidence of what has happened, whether or not Japan's grant of whaling licenses to this particular program, known as the JAPA 2 program, which is the Japanese Advanced Research in something that starts with P and something that starts in A, that I can't remember, whether or not that program, licensed by the government, can properly be described as for scientific purposes. So the court basically took a view that questioned whether the Japanese program did what it claimed to do. And they took, it was about 13 years, I think, of data about whaling activity before and during the JAPA 2 program, and said, okay, Japan claims that it needs this quota for this reason, it needs to get these types of whales for these reasons, this number of these reasons, and so on and such forth. And Japan said, these are the scientific reasons why we're trying to kill all of these different whales. And if we don't do that, the data isn't going to be very useful. We won't be able to come to a scientific insight. We still don't understand very much about whales, which indeed is true. We really don't understand much about their patterns or populations. And the court said, okay, you're telling us that you need to kill 200 minke whales in this part of the world over this number of years for these reasons, and that anything less than that is not going to be scientifically robust. So why is it that you seem content that your program caught 38 whales one year, 83 the next year, 115 the year after that, and so on and such forth? All of the practice didn't live up to the standards that were apparently scientific standards that Japan had claimed. And ultimately the court decided that Japan was not good to its word, effectively, that the things that it had done could not have scientific value, were not sufficiently robust enough from an objective scientific standard, even accepting that it was a valid project. Australia said we should not allow lethal whaling research other than if it is absolutely strictly necessary. The court didn't accept that argument. It was perfectly happy to accept that killing whales was a legitimate way of conducting scientific research, so long as that killing was a robust, appropriate practice in keeping with the well-known standards of scientific reliability, effectively. And they said, what you have done has not met what you said you would do, which means that this isn't scientifically valuable, which means it doesn't really justify being described as scientific, which means, ultimately, that you have violated your commitments under the convention to not kill whales unless for scientific reasons. And the real turning point in that case was when the Norwegian scientific experts that Japan had involved in the proceedings were cross-examined. And cross-examination has happened very, very little in the ICJ. A lot of states don't like it because it's unpredictable. You don't really know what's going to happen. And the Australian Attorney General, Gleeson, was frankly brilliant. And he got to the point of having the Norwegian expert accepting that what had happened was ultimately scientifically worthless. And that was enough for the court to say, right, you have not done what you said you would do. That is not a good faith fulfillment. You might say they didn't use that terminology, but you cannot then claim that this is a scientific exercise, because the data that you've produced, the material that you have been using, the practices that you're undertaking don't meet the universally recognised expectations for robust scientific research. And Australia ultimately won the case. And that was really a much more confident engagement with scientific data than we've ever seen from the ICJ before. And in the article that I've written about the whaling case, I think that it points the way towards, I think, a more positive future where the ICJ will be a little bit more resilient, will be a little bit more intrusive, you might say, and will be more willing to assess for itself, possibly aided by independent experts. I totally agree with you. The court should do that. It really should. If you look at the notorious example, Cameroon versus Nigeria, which is a land and maritime delimitation case, if you're interested in those types of cases. There is a big problem today. So that case was decided in 1996? Is that right? Maybe? Oh no, 2002. Sorry. There's 3 cases in a row, and that's the first of them. The parties are still struggling to realise that judgment. Not because, like Colombia, they've turned their nose up at the court's decision. They genuinely want to follow with the judgment that's been rendered, but they can't. The reason being that the operative part of the judgment, the answer, the decision, is, and they asked for a more detailed decision than was requested in Nicaragua, Colombia, is meaningless, because if you are going to do anything relating to geographical data, you need a certain coordination set, various data that can then be used to map your coordinates onto the surface of the globe, because the surface of the globe is irregular, and you need a fixed point to then project around. And the court just didn't even know that was necessary, and that's apparently like Geography 101 sort of thing. And so now the states are like, you've given us a decision, and the decision is, and Cameroon gets all the elephants. We didn't ask you anything about elephants. It's entirely irrelevant to what our future is. And so now they've had to go back, well, not go back, they've had to create a new commission which has tried to interpret the spirit of the decision and come to a negotiated but detailed understanding of what they think the court meant, because you can't tell on the basis of the numbers that the court gave, because it's in an entirely non-existent scientific language. So that is a good indication. That's a bad story about what the ICJ is capable of, or rather incapable of, and suggests that having a bit more assistance is a good thing, so long as, and this is Sima and Kasone's point, and this is my point, so long as it is done in a transparent, open way. That it should be clear, is that expert going to participate in the court's decisions? Deliberations, I mean. The ICJ undertakes collegial deliberations. It decides on its judgments as a unit. There are separate opinions, but they come together and decide on the outcome. Should the court-appointed experts participate in that? Surely you should take the view of the parties about that matter.
Especially as a matter of responsibility when you're taking not declarative but constitutive decisions.
Agreed.
It's different when you say, you have the right, and see how you arrange to make it happen.
Yep.
That when you say,
this is what you do. Yeah, I fully agree. Another option, which I like talking about just because it sounds so fun, is what's called hot tubbing. Have you heard of this?
No.
So hot tubbing is, is where everyone litigates in the nude. No, that's not it. Though that would certainly make ICJ proceedings much more interesting and really quite disgusting. Hot tubbing involves getting a panel of experts. So the judge, the court, I've just been at a conference, we were talking about when different bodies of knowledge interact. The hope is always that you'll all learn from each other and that there'll be a dynamic expansion of awareness. But there is a growing sense that actually it creates stasis, in a sense, because if I ask any one of you to tell me what is the situation in Colombian politics right now, it would be a view. And I recognize there must be a plurality of views. But the risk is that that becomes the authoritative statement of what the situation is in a highly contested area of knowledge generation, of fact-making, as I would call it. And rather than the court appointing a single expert who might have a particular view, you get 3 or 4 or 5, and you put them in a panel, and you ask them to resolve the very specifically technical matters between them. And you remove their adversarial affiliations, so they don't have a vested interest in the outcome of the case. They're not hoping that one side or the other wins. And they can work out between them, so the story goes, where the weight of the debates go within their specific fields. So the idea is you put them in a room in a hot tub, they fight it out amongst themselves, and they come back to the court and say, there are these uncertainties, but our view is that the least bad or the best in this circumstance is the following. And then the court takes that and uses it. And the question is then, should the court be privy to those discussions? On one view, they wouldn't understand it. On the other view, of course they should. Everyone should be a participant in those interactions. But then you end up with this strange system that is quasi-adversarial, and then should the parties be able to ask questions of the experts? Should the judges be able to ask questions of them? We just don't have agreement on any of those types of things.
How about Amici? I mean, it works for many.
So, the couple of points on that. The first point is that Amici Curiae have no standing before the court's contentious jurisdiction. The only parties that can participate before the ICJ when it's sitting as a contentious body are states. So one option might be to turn it into an advisory matter. And that could happen. That's quite possible. And then if you get something like advisory opinions on legality of nuclear weapons, that's an environmental case. And you got Amici Curiae submissions from a few NGOs. NGOs and international organisations are allowed to make submissions in advisory proceedings, but not in a contentious matter. Could that change?
Yeah, that's the point.
You'd have to change the rules of court, and in fact there is a revision coming. They're just about to start work on it, and in fact they might have already started it. The last rules are from 1978, so maybe it's time. I'd be surprised if they allowed that. I don't know that states are so keen on that. They don't like to lose control of these matters. The other problem there is that you end up with a variety of viewpoints that might be very, very distantly related to the specific concrete matter. So coming from a common law jurisdiction and a common law upbringing, we hate advisory opinions. We hate the idea, or at least a lot of people do. Again, I can't speak for all of the common law, but a lot of people don't like the idea of it because it runs against the principles of how the common law develops. It is a precedent-based system, so courts should adhere to a principle of judicial economy so as to only decide something that requires decision, and they shouldn't say anything else beyond that. We don't like the inclusion of extraneous materials because it runs the risk of distorting the doctrines of precedent and its judicial overreach. And we're very sensitive to that in the common law world. So I think that there'd be some reluctance to accept that. You get it in the WTO though now, and it's working pretty well in the WTO. As a comparator, the WTO is much, much more ready to engage with scientific evidence than the ICJ has shown itself so far. Huh? It's done it a lot, yeah. And it appoints economic experts, and you have on its panelist lists experts from a variety of fields. And in fact, it's becoming less common for lawyers to be appointed to dispute settlement panels than economists and so on in the WTO. But then there is a denser body of rules that are applicable with a greater stability in the WTO framework because everyone is a party to all of the WTO framework, and that's not appropriate in the ICJ context. I think I probably did speak way too long. I said it'd be half an hour. Do you have any questions? That's all I really wanted to say. Is like these are just ideas about what's changing, what's happening, and about a matter that I think is really significant because part of what matters in international law is improving the prospects for making real the judgments based on rules that we've committed to. Enforcement has been a big problem for international law, let's face it. It's one of its great immaturities when compared to a domestic system. And starting to engage with these types of procedural, mundane, specific matters of adjudication, I think is a mark of a growing maturity of international dispute settlement. And I think it's something to be supported.
Well, yeah, thank you. First of all, thanks for the presentation, which was really interesting. Actually, more than asking you something, I just wanted to speak up what I think about all of what you said. And I think it was quite appropriate for you to begin by saying how the ICJ perceived its role, how both the common law and the civil law, although we are forgetting Islamic and other traditions as well, somehow blended, made a mixed system. And I think it's important because indeed the ICJ is very traditional. In my opinion, it's very conservative compared to other international authorities, tribunals, whatever. So indeed, the problem is that the ICJ perceives itself, as you very well pointed out, as having states as its customers. So it's very wary, cautious. But I think that's problematic because, some authors say sometimes that your philosophical background, ideological, theoretical, has an impact on the way in which law is practiced.
Mm-hmm.
And I think it has also an impact here as well. For instance, regarding, you very well pointed out that standard of evidence has been changing. I think that regarding the burden of proof, things may change. There's an article by Rosalind Higgins in which she says that indeed the court has traditionally said that whoever argues a point must demonstrate the veracity of that point, but I think it may change. For instance, in this oil platforms case, the court ended up by saying that it was not necessary in that case to find out who fired a missile. So, I mean, it may somehow show that the court may open up the possibility in the future depending on the circumstances. And I compared with, for instance, the Inter-American Court of Human Rights, which indeed resorts to a dynamic or shifting burden of proof, of course, because it perceives its mission as being foremost about protecting victims in which there is an imbalance of knowledge. So perhaps I know that you invoked sovereign equality formally, but insofar as there are so many theories about it nowadays, perhaps the court could end up by saying in a given case, if there is an imbalance, well, in this case, there's a burden of proof, and I apologize if I am mistaken, if I am misinterpreting, but I mean, this is probably, too likely wrong, but in my opinion, perhaps without expressly saying so, in the whaling case, the court timidly did something resembling this. Why so? Because Australia said something, Japan said, no, we are conducting some scientific investigations, some research, but the court ended up by saying, okay, you didn't demonstrate this. But the point is that the applicant was Australia, claiming that Japan was breaching. So, in a sense, the court asked, since, yes, Australia said this, so Japan defended itself by saying, this is for scientific purposes.
Yeah.
So, in some sense, perhaps the court could be asking, so every time there's an application, a pleading, there's a counterclaim and response. So the court subtly could be using this to somehow, because it is somehow expecting or maybe expecting the respondent or the applicant, whoever, to demonstrate something. Perhaps in a given case, I make a blunt statement, and the other will make any defense, any rebuttal to this, and the court, will then expect the rebuttal to be sound. So subtly, you can shift somehow.
You're absolutely right. So part of the reason I think why the court is elusive on this point is because we don't have the rigid procedural rules that we have in domestic litigation, where there are very clear rules about standards and onuses of proof in domestic systems. We don't have that in the international system. I think what you're saying about whaling is interesting, and you could view it in those terms, because that's an example where it's very difficult to know who's alleging what. Australia is saying you're unscientific, and Japan is saying we are scientific, so they're arguing the same thing anyway. And the other difficulty comes in cases brought by special reference. Who's the applicant and who's the respondent? And Higgins's point that you mentioned, is that the running a tight courtroom article you were referring to?
No, it's an article she made. It was actually a statement, a presentation she made at The Hague in the ICJ, which was later transcribed.
Right.
So,
okay. So she, the statement she made is the orthodoxy. If you say something, it falls to you to prove it. Okay. Which also reflects the impact of the deep principle of consent, because the court, let me finish that point and I'll make the other one. The court won't presume what a state is going to argue, and it won't, it finds itself in a very difficult position in cases of non-appearance, for example, because it has to test the not truth, but a degree of reliability about allegations that are made in circumstances where the other party doesn't show up to argue the opposite. But the court cannot presume what a state will argue. So if the state chooses to not argue something, then it stands to suffer as a result. You mentioned oil platforms, for example. What's a really interesting thing about that case is the fact that the US kept saying on the missiles thing, we know who did it, but we can't tell you. Repeatedly, the US kept saying, we've got all this super high-grade military satellite photography that shows us exactly where this missile came from and what happened, but we're not going to show it to you because it gives it too much away. And the court said, fine, suffer. That's your problem. We're not just going to take your word for it. You have to show us. And if you won't show us, we have no choice but to take the other evidence into account, which is where that decision comes from, really. And I think there is a slightly punitive aspect to that, if you ask my opinion. It's a really interesting example that you cited. But in those cases of matters brought by special agreement, it's very, very difficult to know where a burden should fall. And even in these types of cases where you're actually both arguing the same thing from the opposite direction, again, it's very, very difficult. And because we don't have, rigid rules known in advance, also very difficult. The other part of it, I would say, relates to what I was saying before about overwhelming the court. There is, many, including myself, have argued that there should be some pre-trial phase where the parties get together with the court and some narrowing of the scope of the dispute occurs. And the court has been reluctant to listen to those arguments for fear of being seen to prejudice the outcome, because they don't want to show what might be their thinking about the case at the outset. They need to, which is why also cross-examination and questioning from the bench doesn't happen very much, because that it can give a hint as to what certain parts of the bench might be thinking. So if you ever see the ICJ, it's very unusual. It's the opposite of a hot tub. It's a cold room, because the judge that wants to ask the question can't ask the question. What happens is he or she now, thankfully, writes it down. They go away. They discuss the specific wording of the question, and then the president reads the approved text, and then the agent from the other side says, "Thank you very much, Your Excellency. We'll get back to you tomorrow. I have to take instruction," because they can't say anything that the state hasn't given them permission to say. "I'll get back to you." So it's nothing like, you can't handle the truth or any of this kind of stuff like you see in movies. It's so static and ceremonial. There's this ritual. Why? Because of this requirement of consent and sovereignty, of respect for the equality of the two states. So I couldn't agree more that a human rights court has a very different type of task, and they go about it very differently. You're right. The ECHR less so, but increasingly compared to its past practice, nowhere near as entrepreneurial as the Inter-American Court, but there is a certain, you said balance, I would agree with that, or a symmetry that is necessarily a part of at least individual complaint cases in human rights. What I would say, two other small points. One, you're right about mixed and Islamic systems. They are there are always Islamic judges on the bench, because the composition of the bench is decided to take into account the four legal civilizations, but in terms of procedure there aren't many distinctive contributions, so that doesn't really matter. Higgins, then, I'll say one final point. Higgins was the president at the time that I was writing my work, and who is somebody whose insights have helped me a great deal. Now, she, to my mind, is by far the best president we've ever had, because of her willingness to be a little bit more assertive in her dealings with the parties. I'm sorry to say that she stands alone because of that. Nobody else has done it, and it's really disappointing. It looked like there was hopefully the start of a new trend, but then once her presidency was over, the successes have shown themselves being far less robust. And there are certain judges with certain nationalities who you might be unsurprised to think are very unlikely to give the litigants a hard time. But one thing that is worth noting, when it comes to setting the procedure, to deciding on the character of the litigation, the president meets with the two parties and they consult and they agree on things between themselves.